Welcome to the fifth and final video of the first module of this course on international arbitration. I will introduce you to the main international arbitration institution located here in The Hague, the Permanent Court of Arbitration, commonly referred to by its acronym the PCA. When was the PCA created and for which purpose? How does it function? What is its role in international arbitration today? These questions will be addressed in this video. As explained before, arbitration can be either ad hoc or institutional. The PCA is the most important arbitration institution when it comes to interstate arbitration. It is located in The Hague in the famous Peace Palace, which was built in 1913 to host the PCA. The PCA is an intergovernmental organization and was created in 1899 during the First Hague Peace Conference. The First Hague Peace Conference was convened by the Russian Tsar Nicholas II with the aim, amongst others, to strengthen the means to settle international disputes peacefully to avoid recourse to the use of force. The conference resulted in the signature of several conventions, including the Convention for the Pacific Settlement of International Disputes, generally referred to as the First Hague Convention. The Second Hague Peace Conference, held in 1907, brought little changes to the convention and to the PCA. An important thing to know about the PCA is that its name is misleading. It is neither a court nor a permanent arbitral tribunal. Indeed, it is not a court in the meaning of an international court or tribunal, such as the International Court of Justice. It is also not permanent, since it has no permanent body of arbitrators who are elected and to whom one can submit a dispute. The PCA is an arbitration institution which provides facilities for parties to arbitrate their disputes. It administers arbitrations. In practice, the PCA will act as registry for arbitrations and provide various related services such as communication, logistic and technical support, and linguistic support. The PCA is composed of several organs. The most important one is the International Bureau, which is the PCA Secretariat and is headed by the Secretary General. The main function of the Bureau is to provide administrative support to the tribunals and act as registry for these. The PCA also has an administrative council, which is composed of the diplomatic representatives of the contracting parties. The Administrative Council is a sort of General Assembly, and it is responsible for shaping the policy of the PCA and overseeing the work of the International Bureau. The Council is headed by the Dutch Minister of Foreign Affairs. Finally, it is worth mentioning that the Administrative Council decided in 1994 to establish a financial assistance fund as main objective to help developing countries meet part of the costs involved in the arbitrations before the PCA. Parties can decide to submit a dispute to arbitration under the PCA. In doing so, however, they will have to constitute the arbitral tribunal, which will hear their case and render the award, as I explained in the previous videos. Arbitrators can be appointed from the list of arbitrators which the PCA maintains, but can also be chosen outside that list. The PCA maintains a separate list of arbitrators and experts for environmental disputes and for space-related disputes. The PCA has its own set of procedural rules. These rules, however, are optional, and the PCA thus also administers arbitrations which function, for example, under the UNCITRAL arbitration rules. Nowadays, the PCA is most used for the arbitration of interstate disputes and disputes between foreign investors and states. It also administers, to a lesser extent, disputes between private parties and occasionally also conciliation proceedings between states. For interstate disputes, the PCA has administered and still administers disputes in a vast range of fields of international law, ranging from boundary disputes to the law of the sea, the latter being quite dominant. I should also add that the Secretary General of the PCA often acts as appointing authority in international arbitrations, or as authority to decide challenges to arbitrators for alleged lack of independence and/or impartiality. In this video, we have discussed the history of the Permanent Court of Arbitration and its functioning. I have also explained that interstate disputes in the area of the law of the sea and investor-state disputes are the main types of disputes settled through arbitration at the PCA. The two forthcoming modules will thus focus precisely on those two types of disputes.